Good evening, everyone. We are live on the last night of live stream celebrating Black History Month. I'm super excited to have attorney Barlay with us. He's not only a closing attorney, but an estate planning attorney. So he's very, very valuable tonight because our topic is protecting your legacy and really making sure that we're keeping in our families, we're keeping the assets, especially real estate assets, investment assets. We're keeping those assets and we're able to pass them down and truly build that generational wealth. So I'm Shaheedah Hill, of course, getting you over the hill to home ownership and helping you confidently buy your first home. And I'm going to have attorney Barlay introduce himself to the audience.
Well, thank you, Shaheedah. I appreciate the invite to be on today. It's a very important topic, and so I always enjoy having the ability to talk about this. As you mentioned, my name is Thua Barlay. I'm an attorney with Lueder, Larkin, and Hunter. I'm a partner with the firm. I've been a part of the firm for about 4.5 years now. I do primarily two things. I'm a real estate closing attorney, and I'm also an estate planning attorney. So I've been doing real estate transactions for almost 20 years and have been doing estate planning for the last 15 years or so. So I find that there are synergies between having a property that is yours, a primary residence or an investment property, and making sure that that property or that asset is properly transferred to your loved ones. And so that's why I find synergies between my two practice areas.
That's wonderful, wonderful. Okay, so go ahead and put your questions in the chat. We're going to get to those because this hour is going to go pretty quickly. So we want to get to as many of your questions as possible. But tell us, Attorney Barlay, what is the difference between having a will and having a trust?
Okay, and that's a great question, and actually one of the ones I always seem to answer for clients. So the way I always like to explain the difference between a will and a trust is by using the analogy of a car. So you have two cars, two vehicles, same make and model. You have the will-based car and the trust-based car. When you pass away, that will-based car has to go into the shop, which in my analogy is the probate court, to get tires rotated, oil change, etc. And then it's ready to go on the journey. So in the analogy, the probate court, you get your executor appointed, submit the will, get your executor appointed, and that executor is ready to execute your wishes in the will. The trust-based car, when you pass away, because you've been doing oil changes and maintenance throughout the life of that vehicle, it's automatically ready to go on the journey. So the trust will be transferred from you as trustee to your trustee, or what we call the successor trustee, and that person will then be able to accomplish your goals and objectives. So the difference primarily is in that probate process that a will has to go through.
Okay, that's a good analogy. So let's talk about this. So the will, that car has to go to the shop, the probate court, before it can go on, like your assets and everything else can go on to their heirs, I guess. And the other one, because you've already set it up, goes directly to the heirs. Now, what about the people that die with nothing, no will? Are they on the bus?
They are and they're in that other third vehicle that we really don't talk. Well, they're taking a walk probably.
They're taking a walk. No, okay.
So every state has what's called intestacy laws. It's laws that the state determines that if you don't identify what your goals and objectives are, then we as a state will, within the law, what we call a statutory law, will dictate how those assets are distributed. So if you have a wife, then yes, it goes to the wife or the spouse. I always say wife because statistically speaking, the wife will survive the husband.
We outlive y'all.
Exactly. So we always say the wife survives, but if you have a wife, no kids, then great, everything goes to the wife. If you have wife and children, then the wife and children will share equally. And Georgia's a little bit different than most states. Georgia has a particular part of the law that says, well, not less than 1/3. So regardless of the number of children that you have, your wife will have 1/3, and then the children would share the other 2/3. But again, it's
very complicated. I'm sure it gets even more complicated when you have like not multiple wives, but ex-wife, kids from this wife, kids from this person. Gets very messy. All right.
And I tell people all the time, we have the wonderful utopian world here where, same spouse, same kids, both. And then you have the more realistic world here that remember the kids that we're talking about aren't the kids of the surviving spouse, but are the kids of the deceased spouse. And
Right.
so this could be where you have children from a previous marriage, and now those children that you may not have talked to in years are now sharing property with your surviving spouse. So again, is that something that people want or would have wanted to have happen? We don't know. But as a state, the state just says, hey, we're going to follow whatever the we believe things would have wanted to have been.
Okay, so if you don't make some arrangements for it to happen the way you want it to happen through either a will or a trust, the court decides what they think should happen.
Absolutely. Absolutely.
Okay, very good. So we're going to, you're a big proponent of having either one. Because are people coming to you after somebody dies and they have real estate and they have no will, and then they're trying to, I think I should get it, I think I should get it, you know, those sort, they seek that from you before like the planning part, if somebody already passes and they're coming to you?
So fortunately, I do the planning portion of things. I have a partner that does the probate side of things that we refer out, but I do more of the planning. But I do have people call me and say, hey, loved one passed away, didn't have a will. What do I need to do at this point? And so I always refer them to my partner. But again, it's those situations where it's better to plan than to not. Because we know family members, it may be just $5, it may just be $10. But when you pass away, the family that you think loves each other and gets along well can fight over just the most minute of things.
I agree. And I've seen it happen. So we talked about revocable living trust. So that's one of our first questions. Let me put that up. Is she said, DB Douglas says, is revocable living trust going to be discussed? So when you're talking about a trust, you're really talking about a revocable living trust, because that's what I have. I have a trust.
Sure. So that is correct. The general type of trust that you have is a revocable living trust. There are several other types of trusts, but they are primarily based off of circumstances, depending on whether you're trying to minimize your estate tax exposure. So you have a large enough estate where there may be an estate tax issue, then you may need some sort of a revocable trust. Or if you're elderly or if you're disabled, special needs, there are special needs trusts, Medicaid trusts. So there are variations. But for the generalist like myself, what we talk about when we mention trust are the revocable living trusts.
And that's what I have. And we did a trust, and we could have done either one. And trusts are a little bit more expensive. I don't know about your fees, but they're a little bit more expensive than wills. But in my mind, I was thinking that my family, if something happened to us, they wouldn't have to go to court. So it'd be a much easier situation with as far as assets and everything, because everything was already done. That's why I decided to do the trust. My husband and I decided to do the trust. And I like the level of detail because it really, I mean, it's so detailed. It's to the point of who gets to pull the plug if we're both incapacitated. Like, I don't want my sister, my cousin who might not like me to make that decision. So I have like,
and I think that's one of the biggest distinctions that you've mentioned. I mentioned the analogy of the car, because you can put the same type of baggage, the same type of suitcases in them. But one of the differences, because the trust is effective upon signing, you can put these disability provisions that you mentioned there. So who's going to be my disability trustee if I can't handle my affairs? Who's going to be responsible for doing those things? Whereas if you have a will, you'll have to have additional documents that'll handle some of those things. Because one of the things about wills is the will doesn't become effective until you pass away. And so that's really one of the big distinctions. But yes, I look at it as doing heavy lifting. The question is, are you in a trust? You're doing the heavy lifting sort of upfront. You're redirecting all of your assets into the trust upon the creation of the trust. Whereas the will, the heavy lifting is done after you pass away, when your executor has to gather assets, pay off creditors, and then distribute those assets.
Gotcha. And I chose to talk about, and I'm going to take your question. Let's make sure we get this all out. I chose a family member to be the executor, like my trustee. So if I die, and I pick the cheapest person in my family, that's like the accountant, right? So I picked somebody who I know is not going to mess around with money. And she basically is going to be the person that follows out or, takes control and does everything that, so first, if I die and my husband's still alive, he takes it over. But if we die together, but sometimes in couples that happens, we may die together in a car accident or something like that. So she handles everything. and you have to pick somebody you trust. But what if you don't have somebody you trust in your family? What are your options if you don't trust anybody to be that person?
All right. Well, so a couple of things before I answer that. I'm going to lead into that. But one of the things that you mentioned was that the competent person. So in my firm, I like to tell my clients that we love to work in what we call the rule of three. I
Okay.
want you to identify three individuals. So if the first person's not available or has passed away or doesn't frankly want to do it because there's a lot of responsibilities, then you have a backup to that person, and then you have a backup to that person. So always remember the rule of three, and always identify a competent person, because again, this is a lot of responsibilities. They're literally stepping into your shoes to do what you would have been able to do if you were alive or if you were competent. And so you want to pick somebody who's responsible and able to handle those affairs.
Right.
And then your question about, well, if you have nobody to be able to do that, so if you don't have the three individuals that we mentioned, there are certain banks and certain institutions that can serve as what we call your corporate trustee or your corporate fiduciary. Obviously, there's going to be some fees and costs associated with hiring one, but that's typically in the case where there's nobody. So I always tell clients, I prefer for you to identify a family member, friend, somebody competent. If not, then yes, we can maybe your accountant or an attorney or somebody that you believe can, or another professional that can handle it. And if not, then yes, we go perhaps into the corporate route where we have a bank or another financial institution serve as your executor or trustee.
All right, so I think we've explained those two things well. Let's start taking some questions, attorney. So this is our first one. When you leave property to your children in a trust, how do you make sure those properties stay in the family for generations? Can you make them? Because, I'm going to say real quick, I'm going to let you answer this question. But in my trust, I have that if you on drugs, you're not getting anything. If you haven't graduated from high school, you're not getting anything. Like, we have like different little things in there. But how do you make sure that they don't just take the property, sell it, and buy Bitcoin with it? Like, how do you control that?
Well, and that's one of the things that why trusts are sort of preferable in some situations. And trust can work in contingent in conjunction with other entities like an LLC. So, but to answer the question, how do you dictate that within the terms of the trust? You can dictate how things are to occur after your death. So, if you want to keep it in trust for a X period of time, yes, we have to be cognizant of certain laws that we don't want to keep it in perpetuity, but we want to keep it for certain generations. We can put within that trust certain guidelines as to how to keep it. And if somebody wants to sell their share, we can put into their restrictions on who they can sell it to. So, for instance, you can only sell it to another family member, perhaps in the trust, or give them that first right of refusal. So it keeps it within the family for a period of time. So within that trust document, you can make certain distinctions or certain guidelines or restrictions on how it gets dispersed afterwards.
Yeah, you've seen that in those movies. Like in the movies, they're like, I can't get anything until I graduate. I can't get anything
Correct.
until I whatever. I gotta have a
Correct.
prenup with this. I was like, I don't want no woman marrying you for your money. You might have to have a prenup
Correct.
before you get married. All of those
Correct.
types of things. You
Correct. And
can
that's
put
the
in.
absolute same thing with a trust. Absolutely.
Okay. All right. Our next question, Miss Bishoto. I don't know, BB. We'll call you BB. What happens if the house is not paid off? So somebody dies, the house is not paid off. What happens in that situation?
So this is where proper planning comes into place, because what typically we would recommend or clients would recommend is if depending on what your preference is. So if you want that house to be kept within the family, then I would suggest you have some means of having that mortgage paid off, because the easiest or the hardest thing for a family to be able to maintain is the payment of a mortgage over a period of time, especially if certain family members don't have the financial means to be able to take care of that mortgage. And so that's why we would recommend things like life insurance, primarily, that would be able to pay, or your investments, your 401k, whatever you have that may be able to pay off that mortgage so that it can thereby be mortgage free. So now all your family has to worry about is the maintenance and the taxes, which, depending on the property, can be relatively minimal. But again, that question is great in the sense that you have to look at it as sort of an holistic approach. if you want to do A, you have to make sure that you have B and C lined up so that A can work. So if you want to keep it in the family, make sure that the obligations that are associated with that are sort of minimal so that you don't put too much of a burden on your family members once
Okay.
you leave.
I think this is a really important topic. So we're going to spend a little bit more time on this. Okay. So mom dies and she doesn't have a will. Okay. Let's say she doesn't have a will as to what happens. The house is primarily paid off. Okay. So say like the house is worth 500,000, but it has a mortgage left on it. The balance is 100,000. And maybe that payment is $1,000. Okay. So there's still a payment on there, but there's a significant amount of equity, right? And say mom has 3 children. One children's not doing all that well for themselves, and they really want that money, right? That $400, even that 100,000, 125,000 could really help them. They're like, sell it. They're like, sell it and give me my money, right? As soon as mom dies. The other child's like, no, let's keep this house in the family. We don't want to sell it. It might be worth $1 million in about 3 years or so. And then the other child doesn't know what they want to do. What happens in that case? What happens when everybody's at odds as to what to do? And so what may happen if it goes to court, they're just like, sell it and divide it. And you don't really even have a choice.
Right. Well, in that situation, because we don't know what the mother would have wanted, we really can't say for sure. Now, in this situation, if person passed away here in Georgia, we know if there are no other relatives, no other loved ones, just those 3 children, we know that those 3 children will share the property equally. Now, when there's not where there's not a joint decision as to what is to happen to that property, it will at the end of the day be sold. Now, what I would say is if the person the family member that wants to keep that property has the financial means, then yes, pay off your siblings and keep the property in the family. But we know that's not always going to be the case where the person who wants to keep it has the financial means to be able to do that. So you either have to refinance and pay that person off, and so that you can keep it into the family. But there are circumstances that have to be done to make sure. If not, if there's disagreement, whoever's appointed as the administrator of the estate at the end of the day has to basically sell the property because there's no agreement as to what we need to do in terms of keeping it. So an administrator in that case has 3 responsibilities, just like an executor: gather assets, pay off creditors, and distribute the assets. So if there's a mortgage in there, it has to be paid off. If the siblings don't agree on how it's to be paid off, either one can pay off the other, or at the end of the day, the only way to pay off a mortgage is to sell the property and use the proceeds towards paying that mortgage off. So that's, I think, difficulty in those situations.
Yeah. And is that how often the property is lost in the family because they can't agree and that one person is financially able enough to take on the burden of because the house may only have $100,000 mortgage, but it's worth $500,000. So they have to go ahead and pay those other people off to that amount, and they can't afford to do that.
Absolutely. And that conversation should have happened with mom years before to prepare not only her, but the family in terms of understanding what her goals are, because really it's mom's goal. Mom may not have wanted to be kept in the family. She may have, but once she identified that goal of keeping in the family, the next question is then, well, then how do we determine how that's kept in the family? What are the resources that we're going to leave to allow our family members to keep it within the family?
Gotcha. Understood. Very good discussion. Thank you guys, everyone. Doris, thank you. Hope you guys are enjoying this. I don't know if you'll be able to answer this, but we'll try, Kamisha. My father passed right before retirement. Am I entitled to his retirement money that my stepmother is getting?
Okay. So here's the answer to the question. There are certain assets that are what we call non-probatable assets. So they're assets which by law or by contract go to a particular person. Most retirement accounts have a beneficiary designated there. So assuming that when your father passed on that retirement, he listed the stepmother as the beneficiary of that policy, then everything goes to stepmother, regardless of whether he had a will or a trust or anything else, because by contract, that policy dictated who it's to go to. Now, if the policy was blank, then it would go based on Georgia law. So father passed away without a will, it would go based on what Georgia law. Father passed away with a will that says share with stepmother and daughter. I assume daughter share all my assets. Then that policy would be considered part of the probatable estate and would be part of the asset.
Okay. And I know a lot of you in a lot of different states. So this is just advice, or this is not legal advice. He's not your attorney, but kind of gives you some kind of idea of how you should approach this. Let me ask you this. Is she entitled as the daughter to see a copy of what he said specifically?
Within the retirement document,
So what it said.
that depends on the institution, and I'm almost going to tell you, unless she is the representative of his estate somehow, whether as his administrator or executor, most every institution's a little bit different. So they're what institutions are fighting against are lawsuits, and so they don't want to reveal information that may be private in nature to just anybody claiming to be a child. So just because you're a child of the person doesn't automatically mean that you will have access to his assets.
Gotcha. So really, this is a discussion. And I know the thing is, nobody wants to have these death discussions. Like, right. Where does the money go when you die? What happens when, but these are really something you have to do. Like, how do you recommend that families bring up these discussions when they're difficult? Like, you want to wait till Sunday dinner at the family barbecue? How do you recommend that families bring up this information?
Yeah, that's always it's always the toughest thing, because even as an estate planning attorney, that was a difficult conversation to have with my father when he was alive, and my mother currently. So I think all these are difficult conversations. So always find the best opportunity to have those conversations. As you say, Sunday dinner, when things are sort of lively and when everybody is feeling good, that may be a good opportunity to bring it up, because it's not one of those. I like to tell everybody, estate planning is not a sexy topic. It's not something that everybody wants to talk about. Right. It's something that people for the most part don't. And so find a good opportunity to bring it about and see what that conversation is, and let them know what the alternatives are. So if you let mother know, hey, if you want this house to be kept within the family, we have to make certain things now while you're alive and able to do those things.
Okay. I'm going to take this question, and I'm going to talk a little bit about it. All right. And this is, I was at a closing. I was the buyer's agent, okay. And it was 3 people buying the house. It was a married couple and a mother of the wife. Okay. They 3 bought it together. And okay. At the closing table, the mother says, if something happens to me, I want my portion of the house to go to my other child. And they hadn't had this discussion prior, because they were owning that house as joint tenants with rights of survivorship. So if she died, she was older, so natural part of life, she may die before them. It was going to automatically go to the couple. It was not going to go to the other child, even though that's what she wanted. But it was kind of like a hard conversation to have at the closing table. Like you said, they should discuss that earlier. So let's talk about, she's asking, I'm closing on my first home. I want my sister on the deed. Home closing is Monday. And I know it's like, what can you do? And I know that you can add somebody to your title, but let's talk about when you're adding somebody to your title. What does that mean as far as, ownership?
Yeah. So I always ask people, like I would ask Tayana in this case, why do you want to add your sister? And then figure out, okay, what's your objective in adding your sister? Because there may be other ways and other things that we can do to do that. Because what I always tell people, now sister is probably an okay example, but when you add somebody to title, they are now an owner of your property. And so a year from now, 2 years, 5 years from now, you and that person don't get along or disagree, you can't simply take them off the title to the property. They're now an owner. You have to actually now go to court and institute some sort of a litigation to get that person off the property. So I always tell people, don't be quick to add people to title, especially if you want to. For instance, if, I don't know Tayana's again her objective, but if she wanted to add her because again she's single and she knows that when she dies she may want that property to go to her sister, what I would stress again, look at getting a will. look at doing these things, because what happens now, you buy this property, add your sister there, a year, 2 years from now, you get married, 5 years, you have a child. Now you own that property with your sister. If you were to pass away at that point, your husband would not necessarily get that property, at least not easily. He would have to file a lawsuit. When
With
you
your
when
sister.
you did that, it would automatically go, depending on again how they were listed on the deed, but it would automatically go to the sister, and now the sister would be the sole owner of the property.
And the sister doesn't like the husband and tells you to get out my sister's house.
Exactly. And I tell clients all the time, it's wonderful if we lived in this wonderful utopian kumbaya world, then people like me, I wouldn't have anything to be able to do in estate planning. But because we don't, those are circumstances we have to address and take care of. And so I would say focus on making sure that you have a will in place that says, hey, I want my sister to have this property if I were to pass away. And then if you get married or if you have children, the will can always be amended to change that to now, no, I want the property to go to my spouse. Or else you just have to hope sister and I are still in good terms. And so now sister's going to sign it over because she understands it was really my property. I just added her and I really wanted it to go to my husband and child.
Right.
So
It's
I think
gonna be
that's
drama.
a
And this is what I tell people don't do, even more than your sister. Adding your boyfriend or your girlfriend to
um,
the title.
yeah,
Oh Lord. Can you please talk about
yeah.
that for a second? Why are they
I
adding their boyfriend and their girlfriend to the title? They're not gonna marry you, but you wanna give them a house?
I've been doing closings. Yes, I've been doing closings for almost 20 years, and fortunately, that hasn't happened often. But probably on one hand, I've had a situation where that has occurred, and years later, they give me a call and said, "Remember when I?" Well, first of all, I don't remember closings
I don't
unless it
remember.
happened last week. But yeah, remember when I added my boyfriend on there? Well, I can't find him anymore, and he's left me, and I need to refinance or do something with or sell the property. It's that's
Can't do it.
I apologize exactly. You'll have to find him or institute some sort of a lawsuit to get him taken off the
And
property.
sometimes you got to pay them off just to get them off the title. Like give them some of your
Abs-
money. So you
Absolutely,
really don't. I always
absolutely.
tell people if you're not married, own the property by yourself. Whoever's on the mortgage, or own it separate. Don't
Yeah,
just add people to title that you're not married to. That's what I
yeah,
say. But
yeah.
thank you so much. I appreciate all the kind words. They're loving this information. Um, let me see. Let me see. Let me see. Okay, let's talk about this. I think you kind of addressed this already, but can you put your house in a trust for your kids after you close? That is yes. That's at least what I know, because you may not have kids that
Right,
are born yet. So my kids were
correct.
added. We closed on the house and then we added. Well, yeah, they're not in the trust. Let me say this: they're the
The
beneficiaries for
beneficiaries of
the
the trust,
trust.
correct.
Yes.
So
So
yes, I mean right after you close, you can transfer. You can do another deed transferring the property from you two individually to you as trustees of your trust. And remember when I said that the reason that the trust avoids probate is because all the assets in the trust are held by you as trustee of the trust. And so you have to do a process called funding. That means redirect the assets to the trust. So in the case of a house, you just bought it in your individual names, you would then do a deed from your individual name to you as trustee of your trust. That, in essence, now directs that property into the trust, and then the terms of the trust can be executed upon your death or your disability.
yeah, and that's like for all of your assets, even like your life insurance. Now that has to be into your trust as well.
Correct.
So anything that's going to be handed out to the beneficiaries of your trust, you're going to have to add that asset to the trust.
Correct.
All right, we'll try to answer this question, Jay Love. Let's see. What's the time frame legally? And remember, he's licensed in Barden, Georgia. He's going to try to give you a general idea to get you started. What is the time frame legally you can act on a possible will or trust that may have been in order for a property? Like, it's kind of confusing. How can
Yeah.
you find out that if you were listed as a beneficiary? I guess he's saying that there's a property in another state that somebody might have died and he may think that he has some kind of right to it. How can he find that out?
Okay. Um, so if it were a will, the will has to be probated, and so you can contact the probate court in that state depending on the laws of the state. Um, but also part of the petitioning of a will to a court, that petition process, the person who's petitioning it may not always be the executor, but when they petition it, they have to list down all the heirs of the estate. And those heirs have to be notified. Now, the heirs may not be the beneficiaries under the will, but if you're an heir of the estate, then you have to be notified. At least here in Georgia, that's a requirement. So if you pass away with a will here in Georgia owning property, and I am the, let's say, one of the loved ones, I have to take that will to the probate court. Part of the petitioning process is now I have to identify everybody that's an heir of the estate, and I have to provide them with documentation on what I'm filing as a petition. Now, if it were a trust, because a trust is a contractual document, you don't you won't necessarily have the ability to know whether you're a beneficiary of the trust. Now, the trustee or whoever the successor trustee, the person that takes on the responsibility afterwards, has a fiduciary duty. So they have a duty to notify beneficiaries of the trust terms and what they are to receive. So if the trustee has not notified you, then more than likely you're not a beneficiary. Or if you get a sense that you are a beneficiary, you may be able to go to a court, typically the probate court, depending on the state, and force the trustee to disclose the terms of the trust if you have a general sort of understanding or belief that you are a beneficiary of that trust. But it
Okay, so
is difficult from a trust standpoint, and that's why I tell because the trust is effective upon signing, whereas the will is not effective upon death. A trust is harder to contest because it's harder to argue that that person created the trust, and for some reason they functioned as trustee throughout their life and really didn't know what they were talking about or dealing with, and so it's harder to contest the trust. But there are mechanisms in place depending on the state for you to be able to do that. Now,
okay.
as an extension to that question, and why, if you own properties in different states, in my viewpoint, you are an ideal candidate for a trust, because if you own properties in different states, you have to probate your estate in every state that you have property. And so if you pass away with a will here in Georgia, but you own property in South Carolina, not only will you have to probate the will here in Georgia, you also have to do some sort of a probate process in South Carolina. Whereas if you had created a trust, you would have funded or directed that property in Georgia to the trust, and you would have directed that property in South Carolina into the trust. And so you would have had both properties into the trust and not have to have done a probate in Georgia, nor had to have done a probate in South Carolina. So those are, again, questions that we ask potential clients, and that's why we would recommend a trust over a will.
Okay, and let me say this really quickly, because I've experienced at least the will side of this, what he's talking about. And my mom was the what do you call it, the executor of the will.
Exactly. Yes,
So
ma'am.
the will, the property was left to two family members, but not the person who passed away, not her children.
Okay.
So she left it to people that were not her children. Okay. So when my mom, as the executor, she still had to notify, when he says the heirs, she had to
Correct.
notify her children through
Okay.
probate that this was the will and what was going to happen, because they had an opportunity to contest that will to make
Right.
sure it was valid. But she had,
Mhm.
her ducks in a row. But you still, when you have a will, you have to tell everybody that's an heir to that estate that, basically you didn't get nothing. And this is what's going to happen. So
Yeah.
I think that's what he's talking about. If you think somebody's trying to leave you out of, something that you're entitled to, you have to contact a lawyer in that state and see what your rights are in that state.
That is correct.
All right.
That's
So
correct.
let me take this. We can take this one. Can you put your children on your deed? I know you can, but should you? That's probably the better question. You
Yeah.
can,
So
but
it,
should
yeah, this almost is the same in terms of the answering the question about adding your sister on. So this is what I would say again. Always go back to what is the objective. Is that you want to leave that property to your children? I say do estate planning and not this type of planning, because again, when you add your children, it's an automatic transfer. So it's not a revocable transfer. You can't thereby, if one of your children don't listen to you or do what you need them to do, you can't take them off title to the property. Also, the other problem that you create is depending on the age of the child. In Georgia, if anybody is under the age of 18, they're automatically considered to be incompetent. So if you passed away with your child on the deed and that child was 16 years old, you would automatically cause a probate proceeding to occur in order for somebody to be appointed as conservator and or guardian, meaning conservator is handling the finances for that child and the guardian is handling the person, the child themselves. And so if you pass away where the child is less than 18, a probate proceeding would have to be created or petitioned in order to take care of that child's interest in the property. So again, it may sound real easy that, oh, I have kids, I get along, they're well, and I want to add them to the deed, but you have to think about what the repercussions may be in a situation where either child or children, any of the children are under the age of 18, or you don't get along with them, or as Shaheedah mentioned before, remember, creditors of the children would have access to properties owned by children. So if your child is not good with money or was incarcerated or anything like that, where they had creditors being on deed or ownership of a property, those creditors would automatically have the ability. And I've done closings before where they added somebody on. That person wasn't part of the original transaction, wasn't part of the mortgage. They added that person on. That person had a credit card debt. That creditor attached a lien on the property. Upon trying to sell the property, we have to pay the child. Even if that child thereafter signed the deed back to the person, we now have to pay off that lien because it attached to the property. And so those are some of the things, the ramifications you have to think about when you want to add others to the deed.
And it's not worth the risk. Let's put a pin in this for a second, because I used to be a teacher, and one of the parents, or not even a parent, I think their sibling that was older, added the child to the deed. The child had no idea that they were added to this deed. And the owner of the house went to jail. Okay. And he left somebody else in charge of the house that did not pay the HOA. And the HOA was coming. Now the child is like, she was 15 when he added her. Now she's 20 something. And the HOA was going after her to pay the stuff on the HOA. So let's make this clear. You could add somebody to your deed without their permission. Is that correct? In most states, or at least in Georgia?
That is correct, because the only person that needs to sign that deed is the person doing the transfer. So not the person receiving it, it's the person doing the transfer. So so if you add somebody, you can add anybody you want onto that deed. But again,
your kids may not want to be on your deed.
Exactly.
Handle your business correctly.
Figure out what the objective is and find another alternative or estate plan in place to make sure that that objective is accomplished upon death.
Okay. And if I'm passing your question, I may come back to it, but I want to make sure we're getting some general questions in as much as possible. The more specific you are, the more that you probably need your own attorney, but I'm going to try to get as many general questions that will help the group as possible. So let's talk about this for a second. And I'm only focusing on trust questions for tonight because we're trying to protect your legacy. And then after we answer this question, Attorney Barlay, we're sponsored by Credit Sesame. So I'm going to talk about Credit Sesame for a moment. Sure. But let's talk about this, because in this seller's market, a lot of sellers are telling you what attorney to use. Is this a problem, or is this something people should be concerned about?
Not necessarily. One of the things, the identification or the choice of an attorney is a negotiable item. And so whoever has the most negotiating ends up selecting the attorney. Now, the attorney always, in a finance transaction, the attorney, regardless of whether they were chosen by the seller's agent or the listing agent or the selling agent, the buyer's agent, I know there's confusion there, but regardless of who the attorney was chosen by, the attorney in most transactions, most finance transactions, represents the lender. So we have a fiduciary duty to explain documentation, to explain things to both parties. So there's really not an issue there in terms of whether it was the seller that agreed to the attorney or chose the attorney as opposed to you. Okay. So that's a negotiable item. Did I make the wrong decision? I don't think so. What I would say is this: make sure that when you are at the closing, or even prior to the closing that you fully understand. Because when you leave this closing transaction, you're going to be responsible for whatever the obligation is. You're going to be responsible for paying that mortgage, paying the terms on that mortgage. And so make sure that the documentation that you signed was what you understood and agreed to prior to. At my closing and what my associate, we do the same thing. I always explain a document to you before you sign it. Now, I may not go into detail line for line, but I explain the importance of that document. And so, what I would recommend is always understand what you're signing prior to you signing it. And that makes it easy. Always ask questions that are necessary so that because again, when you leave that closing, you are going to be responsible, not the closing attorney, not your lender, not the person you added onto the deed afterwards. You are
You.
responsible for it.
All right. So I'm gonna do my credit sesame spill. Please put your questions in the comment. How you have a little break, attorney. All right.
There you go.
So our sponsor this week is Credit Sesame. Credit Sesame allows you to monitor your credit for free. Credit monitoring is an important part of the home buying process. Credit Sesame offers a free digital debit account, Sesame Cash, which is the first free all-in-one account that can help you automatically grow your score. With Sesame Cash's credit builder, the money you already have and the daily debit purchases you make can now build your credit history. You're able to check your score every day to track your growth, and you'll get paid cash rewards as your score goes up. Credit Sesame already helps people monitor and improve their credit with no credit check required. Now even the millions of Americans that have very little credit history can help build it using Sesame's Cash Credit Builder account. Credit Sesame can help you build your credit automatically without a traditional card. Sesame Cash gives you all the credit building benefits of a credit card with your debit. There's no credit check and absolutely no fees or interest. Just buy the stuff you would normally buy with a debit, and they automatically report your purchases to the bureaus to help you build your credit history and score each month. Since it works with your Sesame Cash account, you only spend the money you actually have. Credit Sesame also pays you as your score goes up, $10 for every 10-point increase in the first 30 days. Sesame Cash Credit Builder grows your score and pays you as it goes up. Review the website for full terms, and I'll have a link to Credit Sesame's Sesame Cash in the description. Thank you so much, you guys. Thank you. Thank you for everyone enjoying the info. Rose, thank you for joining us. Chantrice, thank you so much.
And Shaheed, I'm going to say a perfect segue. Again, if you that I can't stress again the importance of credit.
Okay, let's
Let
talk
me
about that. Yeah.
say that again. Credit is important.
Yes.
We've talked several scenarios here, not only about you buying a house, but we've talked several scenarios here that if you have good credit, it can avoid a lot of issues in the future. Now, I've been blessed. I married a wonderful wife because prior to me getting married, my credit was probably low.
Tell me about it.
College, every credit card company that had somebody sign up, that was me. I was at the table getting a free T-shirt and signing up for it. Whereas my wife was more directed in that, and so that's, I think, a blessing, and because my credit is now where it needs to be, and it allows me to do certain things that I would not have been able to with bad credit. So if you, again, I know this is estate planning, but if you leave here with anything, make sure you have good credit. Absolutely.
Agreed. All right. So we have a question. Parent passed, and we found out, sorry for your loss. We found out someone else owned 3/4 of the house and he owned 1/4. The person never paid anything, mortgage or taxes. What is the best way to attempt probate? And I'm assuming, how would they own the house? I guess through like a quick claim deed or something like that, possibly.
Yeah, so I don't know how they acquired that ownership upon. So I just assumed when they bought the property, there were 4 people, and that's why the parent only owns 1/4 of that.
Okay.
Now, yeah, so this is the difficulty, and because basically probate is only probating 1/4 of that property. It's not probating the entire property. What would have to happen? happen is a separate lawsuit trying to determine true ownership of that property. So it's whether getting the other three people, I assume there are three other owners, to sign it off saying we understand the property belongs to the parent, so we're willing to sign a deed transferring the property back to that parent or to the parent's estate. If they don't agree, whether they now the payment of mortgages, the payment of taxes over a period of years, those are all things that can be used in a lawsuit to prove whatever you want to prove, but you still have to go through that process. Now, unfortunately, I am not a litigating attorney. I always want to be on good side, so I do real
Right.
I
You want to
good
keep your
law in a
hands
sense.
clean. You keep your
We
hands
don't
clean.
argue much at a closing table or doing estate planning, but again, that's those situations. So I can't fully explain what would happen, but I know that some sort of a lawsuit would have to be in place to be able to determine true ownership of the property. Outside of that, the only thing from a probate standpoint that can be done is your parents' 1/4 interest in that property.
Okay. And let's talk about this. This is another conversation you need to have. You don't need to wait till somebody pass away to find out your parent don't even own the whole house. Let's
Absolutely,
have those conversations up front so you're not
absolutely.
surprised about what's happening, right?
And again, difficult conversations. So we're not saying that it's going to be difficult, but again, have those conversations because parent would have probably said, "Hey, I'm yes, I own this property with three other people. I only own 1/4," and that is when you would start because parent would probably be in the best relationship with those other individuals to be able to make sure that things are transferred. But after the fact, it's very hard to make those distinctions. Maybe
Because
the
you never
agreement
know. Yeah.
because if I represented the other three people, maybe the agreement was that the parent would pay the property taxes and the mortgage, and maybe the parent used my credit to get the property, and so that's why I'm the owner. But their responsibility was mortgage and payment to keep us all happy. We don't know what the circumstances are, so now asking a court to make those determinations is going to be very difficult unless you have proof or evidence. Which again, payment of mortgage, payment of expenses could be the necessary proof, but that's up to a judge for sure.
Okay. All right. Good discussion. All right. So Satishia, I believe it is. So my boyfriend has land in South Carolina, and a lot of us have land. It's probably a whole nother video that,
Correct.
families have land, especially, when there was a great migration to the north, a lot of land was left in the South. And that's another thing talking about Black history. A lot of us do have land and a lot of people own it together. And it gets passed down and passed down and passed down. The more people,
and,
the more
and
cumbersome it is.
split up, and that's the problem. And it gets split up because families don't want to keep it together, and so it ends up being split, and then the value of that land ends up being less, and then you have taxes, and it gets taken back
And
because
who's
there's a
paying what and
failure to
all of
pay
that.
taxes. Exactly, and
So it said
that's what.
he said it was passed down, which what does that mean? What does passed down mean?
Yeah,
It
hopefully
was
by
passed
will, but
down, and now how does he get that land? And I think you've kind of discussed it. Was there a will? Was there a trust? Or do you have to go to
correct,
court,
correct.
basically?
Correct. You have to determine how that passed down looked like. So, and basically, you almost have to go back to the family tree. How was it passed down? Was it passed down by will? The will would have identified. If it wasn't passed down by will, then you got to go back to the family tree. When that person passed away, you look at what South Carolina says in terms of who owns the property now when that person passed away, and you look at South Carolina and all to dictate who the heirs of that estate would be, and then it would just keep going down. So they could own a particular portion of it, but you'd have to go based on South Carolina law. And unfortunately, I'm not barred in South Carolina. But again, go find out how they died with or without a will, and then it's dictated by that particular document. So if you have a will, look at the terms of the will. If you don't have a will, look to what South Carolina says that property should how that should be distributed.
Yeah, Google's going to be your friend, at least to start with. Google
I
is going to
agree.
be your friend. Yes.
I agree.
All right. So I want to put up this question. He answered the question about how you can leave. She has this question: how can you leave your home to your adult children once you pass away? A will or trust?
Will or trust.
Will or trust. You're coming
Absolutely.
in a little bit late. He kind of explained that at the very beginning. Learning a lot from your channel. Thank you so much, Lynn Brown. please hit the like button if you like this content. I know, like he said, Attorney Barlay said, this is not the sexiest information, but we need this information definitely. So if you like this content, you want to have him back, definitely hit the like button on this video. This is a good one. I want to put this one up here because a lot of people, they get to their closing costs and they're like, why I'm paying that title insurance? I can save $1,000 if I don't pay that title insurance. Should they waive the title insurance? Because since it says optional, right? Should they waive it to try to save a couple of dollars?
So that's a great question. And in full disclosure, I always hesitate a little bit in answering this question because full disclosure, the attorney, once the policy is purchased, we get a portion of that policy. So yes, we always want you to get owner's title, but this is why I think it's important to get owner's title. Depending on how much you are investing in this property, owner's title protects you from here on out. So if they found out 5, 10, 20 years ago that property wasn't properly transferred, or your neighbor's fence happens to be on the property, all those things that could affect your ability, your title, your ownership of that property, your owner's title insurance policy will protect you from here on out. You would just file a claim with the title insurance company. They would have the attorneys and they would make sure that you are whole. So I always tell people, you look at it as an investment. So the more that you're investing in this property, the more you want to protect that investment. So for cash transactions, that is a no-brainer. Every person who purchases property cash should purchase owner's title insurance. It shouldn't be. The more you have to pay in terms of a down payment on a property, you have to do, again, a cost-benefit analysis. But again, it's a one-time payment for a lifetime of no worries, basically, at least from a title standpoint. So I think it's always important to do that.
Right. And the lender is going to get it anyway. Like the lender's going to get their policy.
You are paying for the lenders. You are paying for the lender's policy, and you better believe that they will get a policy when they're giving you a mortgage or a loan.
Yeah, so they're going to be covered. So you want to be covered because you're making a big investment. Like the average home price is going from like $350,000 to $400,000 or more, depending on where you are. That in relation to it, it's a small amount for that level of protection. And so I would say go ahead. I've only had one client probably of the last 2 years that waived it on new construction because money was really tight. And it's very difficult. And I told her, just don't do it. It's not a big deal. I think it was like $750. The money was really tight. But you can't add it. I think you can add it a couple of days after closing or something, but you can't add like 2 years later. Correct.
Depending on the closing attorney, I think we offer a 60-day after closing for you to be able to purchase the policy with the same benefits or deduction, I should say. Afterwards, I don't think
like most you can't go back when there's an issue. You can't say, "Let me add that title."
Oh yeah, no, yeah, an issue just cropped up, and I'm going to come back and no, unfortunately,
it's going to be too late. It's going to be too late. Thank you, guys. Thank you so much. Let's see. Make sure. Let me see. I'm going to get this one. Chantel. You see Shantae's question? I think we're going to put that one up. All right. Shantae. My dad has a house that he added me and my sister on the will, but his in-laws have been living in it since my grandfather was living. So I guess my dad has his parents living in it. Is that how? Yeah. His in-laws living in it. Your grandparents, I would think. Since my grandfather was living, his dad left it to him. So if he passes away, my dad, can they get I can't even see this now. It's off the screen. Shantae,
I think she probably means, do the in-laws have the ability to get that house? So the short answer, obviously, it depends on, now if the father created a will and within the will said that property was to go to sisters, it doesn't matter in terms of who lives there. The will, if the father owns the property, then the property is going to be transferred to the sisters upon his death.
Okay, very good. And I'm going back through this. What do you think? Let's talk about costs a little bit. I know it's difficult depending on the circumstance, but about how much? Give us a range. The range, at least in Georgia, of how much a will costs for you to get a will, and then a range of how much a trust costs for somebody.
Well, I can't speak for. I'll just speak for my firm and what we charge And I always like to tell clients starts. That's the key word because we always customize your documents to you. And so your circumstances may be different from others. I always tell people the same thing. We have two millionaires, both with the same amount of money, but one of the millionaires has 5 kids. Two are minors, and the third is in jail. The other millionaire has the same 5 kids, but they're all grown and they're all fine and doing well in jobs. You can see in those circumstances, we're having to draft more for the millionaire with minor kids and with kids that are incarcerated than for the millionaire with adult children. So there are differences based on the customization. Now, our will-based plans start at 750, and our trust-based plans start at 2,500. Now, the reason why I say based in both of those conversations, and I think we didn't talk about it in this presentation, is that the will and the trust are central documents in the plan, but they're not the only documents. So that's why I always refer to it as a will based or a trust based. So in a will based plan, the will is the central document, but remember, the will doesn't become effective until you pass away. And so in a will based plan, you have a will and you have other documents that we call ancillary documents. So in a will setup, you'll have a power of attorney, so that that's the document that would take into effect if you were to become disabled. You have in Georgia at least, you have an advance directive, which in other states is called a healthcare power of attorney or a living will, that actually dictates what is to occur if you were still alive, but had to make medical decisions. So you were in a coma or you had a terminal illness, you couldn't communicate. Who would be able to make those decisions on your behalf? In line with that document, there's what's called a HIPAA authorization. So when your healthcare agent has the ability to make decisions on your behalf, they need to have access to your medical documents. And HIPAA is the federal law that protects the privacy of your medical information. And so you have to give authorization to those individuals that you've identified to make healthcare decisions. You have to give them access to your medical records. So that's why we always say based plans, because they don't just include one document. So in the trust-based plan, the same thing. Again, you'll have your trust, and even with a trust, you will have a will. But this will in a trust scenario is called a pour-over will. That is simply in case you forgot to transfer things into the trust or you acquired them after the fact. The will in this scenario would be a basic will that would just tell the executor, hey, go to probate the will, get that asset that you didn't put into your trust, and pour it over into the trust or add it into the trust. Also, guardianship provisions. If you have minor children, those have to be within the will. So in the trust scenario, the trust-based plan, you still have a will. It's a skeletal will that has certain things, but you still have the power of attorney, the advance directive, the HIPAA authorization. We even have clients in their plans do what we call memorial instructions. That means tell us how you want your funeral to be conducted. Because again, if you think family members get along, the first instance of when they won't get along is at the funeral. And so if you're able, now it's not mandatory, but if you're able to put in guidelines as to how you want your funeral to be conducted, what hymns to be sung, what organizations to participate in that process, it's best to put it in that plan and make sure that everybody understands it. So that is again a short question, but again it talks about the depth or the level of detail that is required
Right.
for the
And
plan.
I'm gonna show you, and we didn't know each other at this time, but my trust, I get it. It's a lot of pages in here. And it was a lot of hard conversations, to be honest with you. Okay. So we had to sit down, and this is the first time you're really thinking through your life. Who do you want to make these decisions? What happens if we all die? Who do you want? Like, so say you have to think about if we're all in like a car accident and our whole family dies at the same time. What happens to everything then? Does your side of the family get it? Does my side of the family get it? Do both of them get it? Who's going to be mad? Who gets the most? You're thinking about all of those things. You have to think about, okay, what if my kids, they die and they haven't gone to high school yet? What if they, like you said, do we want them to go to college? Do we want them not to go to college? All of these things are like, you have to think about. I'm sure you give like some kind of worksheet and say, okay, what about this? And what about this? And what about this? I mean, we
Yeah,
had to the person, we didn't agree on who should pull the plug. I said, no, I have a very, very nice sister that would leave me alive a lot longer than the other sister. You gonna make that decision. We really had, and my husband wanted somebody else to make the decision. So like all of those things you're gonna have to think through. And it's really like a powerful document. It really is for somebody. And you get it. Like I got a hard copy and we have it electronically, so you can send it to the trustee. But it's really something. But once you talk about it, you're done. Like we set a time, we're going to make these decisions. And once we don't like talk about dying every day, but we put a month to it and we said, okay, by the end of this month, we're going to make all of these hard decisions. But once it's done, unless something happens to the trustee or something happens, we get divorced. We're not going to get divorced. I didn't say that. But if something happens, you have to redo the trust, right? So you can't just have the same trust. We're going to answer like 2 more questions. Thank you so much for staying on this live. Please like this content, so we'll do it again. I want to answer Shantae's question. I'm married, and if me and my husband are separated, so I guess you're going to buy a house during this time of separation, is she obligated to put him on the deed to that house?
The short answer. So short answer is no. If I understand the question correctly, Georgia is what's called a separate property state. That means simply because you're married to somebody doesn't necessarily mean that you're obligated to that they own own assets jointly or together. So if you were separated and you purchase property, then you would be able to not have to add them. But again, that's an estate planning conversation. Family law conversations there's an equitable right in assets. Now the question would be, if you're separated with your husband, does your husband still have an equitable right to the property even if you didn't add him to the deed? Those again are difficult conversations to have. But what I would say is, from an estate planning standpoint, no. If you own property, it's separate property. You don't necessarily have to add your husband to title to the property.
Okay. And let's and I want to say this. There was a big story in the news. A couple was married. One, and this might be more of a family law thing, but one spouse got dementia, right? And so they were taking care of that. It's a big story that spouse got dementia, and he was taking care of that spouse, but he also had a girlfriend on the side. Like when I was doing my trust, I was like, I'm attorney. How can I avoid that not happening to me? Like having a girl, but he was like, you're still married. They weren't married. She don't know what's going on. And I was like, I said, if that happens, I want my child to be my, what do you call a person? My,
your successor trustee, disability
trustee, during that disability. So this is just not when you die, especially a trust. This is if I'm incapacitated. If I don't know who I am. I don't know who you are. I don't want you putting me in no room in the back while you with your girlfriend in the front. Like it's like that level of discussion and conversation that needs to happen.
Yeah, and depending on the document, as soon as you divorce a person, they're not necessarily the divorce also will force them to not participate as a fiduciary, whatever you've identified them, whether it's your power of attorney or your trustee. Within the document, you can make certain distinctions. If I happen to divorce this person, then they will no longer be my power of attorney under this.
Because a lot of times this happens a lot. I think with life insurance, people, especially life insurance with their job, they put their husband or their spouse as the beneficiary. They never change it because a lot of men don't handle business. Yeah. My dad paid child support till I was about 25 because he never took it. He never went to the child support to take it off. And my mother just called it alimony at that point. Because, so a lot of people, they'll die unexpectedly and still have their first spouse on their life insurance. And guess what? That first spouse gets that life insurance.
By contract and by law. Yes, absolutely. And that's why I have people do homework. And some of my homework, even if we're doing a will-based plan, because remember I mentioned life insurance isn't covered by the will unless you listed your estate as a beneficiary of the life insurance. But I'll always have people do homework because they create these policies way before the estate plan. And so I tell them, just call your insurance company up, ask them to send you a one-page document that lists who your primary beneficiary is and who your contingent or secondary beneficiary. And it just makes it so that you are reflecting. So if your wills are your objective is to have spouse be primary and kids secondary, make sure that the life insurance policy reflects that. And within the binder, similar to what Shaheedah has, we do the same type of binders with ours. There's a section in there for other financial information because you want a central repository, a central location for everything, whether it's directly estate planning, whether it's the will controlling it or it's other documents. You want your family members to have the least amount of work once you pass away. And so just put bank statements in there, put identifiers in there that tell people these are the assets that I own.
Yeah. And then we didn't talk a lot about life insurance on here, but have life insurance as well, because life insurance, in my mind, I don't want you to be broke and sad. You're going to be sad. Your kids are going to be sad and devastated that you died, or your spouse is going to be sad and devastated. But don't be sad, devastated, and broke, where you got to sell the house just to live, right?
Yes.
So have enough life insurance where they have enough money to. And we just had, when I was teaching and my husband was teaching, we just had the let me take this one off. We just had the policies that the schools offered us. And in order for us to increase those amounts to, like, $500,000, $1 million, whatever, they have to come to your house. They will draw your blood. They will weigh you because they're trying to figure out, right? They're trying to figure out what's the likelihood, like what's my risk factor here. And we just have term policies, but my policy was less because Black men have a lower mortality rate, right? Or they are, his policy was a little bit more, but it still wasn't expensive. But just know, like, my thing was, once you have like almost a checklist of things that you need to do as an adult, one of those things is get life insurance. And once you do it, it's done. Get a will or a trust. Check that off, get it done. It's just a checklist of being an adult and having responsibilities. That's how I see it. And even though they're difficult to do, once you check it off, it's not like you have to be thinking about it all the time and having those discussions all the time, but just check it off. That's part of being an adult and, making those kinds of decisions. I wanted to, this question, I thought this was a good one. Should I have a trust if I'm single and no children? And you may have this happen a lot, because then we're talking about leaving it to your kids and your legacy, whatever. What should somebody who has no children have?
So so the question is not. So the answer is going to be your typical attorney answer. It depends, because it's not simply whether you're married and children is not the simple answer. The simple answer to the question. What I would want to know more is, well, first tell me about your other assets. Tell me about what do you want to have happen. You're single, no children. So what happens if you were to pass away? What assets do you own? A home? Where do you want that home to go to? Whom do you want it to go to? So all those questions will dictate the answer. So if you only have, if you have homes, like I mentioned, I could be single, no children, but I have a home in Georgia and I have a home in South Carolina. For me, that's an automatic red flag. You need a trust.
Okay.
But I always have conversations with clients, because the initial consultation is simply that. You fill out a worksheet, we talk, tell me what your goals or objectives are. Then the next meeting, I call my design meeting. That's when I determine whether I recommend a trust for you or I recommend a will for you. Not everybody needs to be in a trust. A trust has definite advantages over a will, but not everybody needs to be in the trust. It just depends on the circumstances that are associated.
And especially, I think, even with, I like the trust for not dying. What if you don't die? What if you're disabled and your assets have to take care of you? Who do you want to handle that business if you can't make those decisions for yourself?
Correct.
You don't want somebody that's not really good with money trying to take care of you the cheapest way possible, right? So I would think that you need something in place maybe for that.
Correct.
Yeah. All right, Attorney Barlay, how can they reach you? And I'll have all of this information in the description as well. What's their best way to reach you? Is it your website or?
Yeah, I can give my email. I can give my work. So my work number is 770-602-9924.
Say it twice, just in case.
770-602-9924. My main office is in Conyers, is about 20 miles east of Atlanta. But one of the benefits about my firm is that we have 20, I keep losing track. We have about 24 offices in Metro Atlanta. So we have exposure throughout And one of the things that COVID has sort of helped us is we can cover almost anywhere in Georgia. I have a potential client in Hinesville, Georgia, which is down by the Savannah area, and so we're able to facilitate
Go
that.
everywhere.
Absolutely.
Let me
Email
ask you this.
address.
Sorry, and I'll let you. And we will have all of this in the description. What if they're
Perfect.
not in Georgia? What's their best way to find an attorney like you, knowledgeable like you?
Great. So I'm a part of a national network of estate planning attorneys called Wealth Counsel. And what one of the mechanisms that Wealth Counsel has put into place is a website. So if you go to estateplanning.com, you're able to put in your zip code or your city name of the city, and you're able to find attorneys similar to me that use the same type of software, that have the same general experience and knowledge, and you're able to find attorneys within your general area to be able to assist you. So I would recommend, again, if you're not within the state of Georgia and need estate planning assistance, go to estateplanning.com, relatively easy, and you're able to find an attorney near you.
All right. Thank you so much. Daryl says he loves this show. Much needed. This was my plan already. I want to keep my estate intact. Thank you. Let's give them one thing to go away with. I know we said credit, right? That's most important.
Absolutely. Credit. Make sure your credit is good. Make sure you plan. Again, as we talked about in the show, a trust is beneficial. It has its advantages, but make sure you plan, even if it's a will, and understand that it's not only those two documents, that there are additional documents that are part of that plan. But either way, what I want you to leave here with is a general understanding that I need to seek out an estate planning attorney to make sure that my goals and objectives of what I want to happen if I'm disabled or if I pass away are being accomplished, and rather than just leaving it up to the state or happenstance about what should occur.
Right. And then if there are children on this live stream and not their parents, what should they be telling to their parents?
I would make sure that you tell your parents the importance of this. I know most times, and I have conversations with adult children all the time that want to take the lead in these conversations, and it's wonderful. But I always tell them you can take the lead in terms of getting the information, but at the end of the day, your parents are the ones that are actually creating the plan. And so my conversations would always have to be with parents, so that they are the ones that when I create documents, it's for them and not necessarily for loved ones. And I always, as an aside with adult children, I always say, when I'm having conversations with your parents, either everybody's a part of that conversation or nobody is, because we never want a situation where one child is leading the conversation. We create documents, and years later, there's some discussion about, well, it really wasn't my parents. It was that one child that you did all the work for, that it was their wishes that you accomplished. And so I say everybody participates or nobody participates.
All right, so tell them that you're taking them to brunch or something like that, and then make a turn to the estate. Like go to brunch after and say, let's go talk to like an appointment with for attorney to talk about our estate. At least to start the conversation.
Yeah, they made me need. There's more preparation than that, because we need some certain information before you show up. But that's a great way to at least start the conversation.
All right. Thank you so much for joining me. Thank you so much for this information. I know it's been valuable. Thank you, everyone, for joining me all week on these live streams. I really appreciate it. Hit the like button. Thank you so much. All of his information will be in the description of this video. Thank you so much, you guys. Have a great night.
Thank you.